Massachusetts, please pop that into the chat box. We like to see, where everybody is kind of, coming in from. But this evening that we have a wonderful lineup for you this evening. We have two amazing attorneys that are here with us. We have two wonderful attorneys that are on the line with us, and we're really happy to have them sharing this evening about estate preservation, estate planning, but just, and again, why every person of color, I don't care if you're Latino, Black, and Asian, whatever, and especially in our community, why it's important for us to focus on having a estate. Maybe you don't know what an estate is, or maybe you think that you don't know what an estate is, but they're going to be clarifying all those tonight. So if you have questions, Janisha will be monitoring the Facebook Live, as well as if you're here on Zoom with us, feel free to pop in any questions that you may have in the chat box. Some of you did send your questions ahead of time, and we really appreciate that as well. I see some people coming in from Boston. So again, if you're even if you're on Facebook Live, please tell us where you're coming in from, which is wonderful. So the first person that I wanted to bring up is the magnificent Shabnam Marsh Masarmi. I hope I didn't butcher that.
You got it.
But man, listen, she is a powerhouse. I mean, listen, I'm not even going to steal her thunder. There could be like no introduction considering what she has doing in her law firm. But she's the owner and founder of her own law firm here in Massachusetts. You guys, not only is she decided, to do something local, but she decided to take it national. And she's also practicing law in New York, in Florida, possibly some other states. I love that. Wherever our people are and need that information, she's making the trek to go out there. Again, her areas of specialty is estate planning, real estate, and bankruptcy, okay? Since May 2015, she was designated to serve as a foreclosure commissioner, you guys, for the U.S. Department of Housing and Urban Development. I'm telling you, like no flies on her at all, right? She was also appointed by the governor of Massachusetts to serve on the Black Advisory Commission. So again, just a wealth of knowledge, expertise, and professionalism, okay? She's been consistently recognized in 2014 as a rising star, as published in Boston Magazine and New England Super Lawyers. She received her undergraduate degree from Boston College, plus her doctorate from Suffolk University Law. Again, you got to be a smarty patati to get in there. So again, no flies on her, okay? She also serves on the board of real property and the probate section of the National Bar Association, okay? I believe for Region 1, maybe she can just maybe talk about what that means. I'm not sure what that means, but again, just an unbelievable amount of expertise. Now, Denisha, I didn't get the other bio. All I have is one, but one thing that I did want to talk about is the other gentleman that is on the line, and I also believe that Shabnam and Terrence had partnered. They decided to partner. Again, we always believe in, that's why I love that these guys are on here. Instead of competing, they decided to collaborate and bring that knowledge and their value in their expertise, okay? So we have on the line Terrence Quinn Esquire, who has his law firm is the TGQ law firm, okay? And now he is coming in from Michigan. just extensive years of knowledge when it comes to estate planning, and all the aspects of estate planning to make sure, and also has a specialty in elder law. Okay, so for some of you out there that have some either elderly parents or grandparents, again, this is why we're happy that you're here this evening. Please, you guys, if you're on, definitely share the link with individuals that may need to hear that. Anybody that has children, has property, or any type of thing that you own and you want to make sure that you're able to protect it and pass it down, please make sure you just share the Zoom link, as well as if you're on Facebook Live, tag people in and share with that. I'm actually going to turn it over to Terrence so he can, again, talk to you a little bit about what his background is and some of his experience. And then what we're going to do is just dive right in. Again, just full of knowledge. We got two experts here. So Terrence, you can feel free to add in so everybody knows just what you are bringing to the table this evening.
No problem. Thank you so much, Michelle. We're excited to be here to help out and do this presentation with you all today. This is information that is near and dear to our hearts. And years ago, both of us decided that it was important for us to get into this practice area so that we could help people in the right way. We realized that a lot of people have misinformation when it comes to how to properly leave generational wealth. And so one of our major interests is to make sure we provide good information to people so that they can make good decisions. We spend a good amount of time correcting plans that have been done in the past that weren't done correctly, but also building plans that haven't been done at all. So our focus and our goal is to make sure that we provide information to people that they can use to build a proper plan for themselves. And that's what we plan on doing tonight. I've been practicing in Michigan for a good amount of time and own my own firm since 2008. Practiced at a firm for years before that. And, we've just done a lot of other things. And so anybody can go to my website and read up on that. I want to get right into the information and make sure we jump in. But before I do, I just want to say thank you to you, as well as Denisha McDonald and our Village Initiative for putting this on. I think it's an amazing idea. And I think that everybody and anybody should be on this so that they can get good information. Chad, I'm gonna turn it over to you just to give some comments before we jump in.
Of course. And, we're just so grateful that you two, have this platform to allow other people to come in. I know a lot of people don't have access to attorneys. So by allowing this, you guys feel free to ask any questions, or if you have any comments or concerns, feel free to drop them in the link in the chat box. Denisha's watching the chat box, or our poll that Denisha or Michelle will tell you guys about.
Yeah. So we're going to get started now. I believe we're going to just jump right in. Speaking of the poll, everybody who's watching, if you could, you see right there on the right of the screen where that link is highlighted. Make sure now that you go on. I would recommend using a separate device than the one that you're watching this presentation on. Use your cell phone if you're on the computer for the presentation, or use your computer if you're on your cell phone for the presentation. But go to that link, because we're going to be doing, there are several slides where we're going to be asking you questions, and we want to get live responses so that you can see what these look like. Now, please know that it's completely anonymous. We have no way of knowing who answered in which way. We just see the answers, period, and you'll see them up there as well. So go to tgqlaw.participole.com right now, if you could, because coming up shortly, like 2 or 3 slides in, we have our first poll. So once again, tgqlaw.participole.com is where we want you to go. But let's jump right in. Let's jump right into this. Before we get started, Shab has a bit of information for you all.
This is our disclaimer. We're here for informational purposes only. Nothing we're saying is leading to any attorney-client relationship. This is not legal advice, as everyone has different situations and scenarios that pertains to them. You can take a second and read through all of this. I'm sure you guys are mostly familiar with this language, but again, nothing in here is attorney-client relationship. And again, it's just informational.
And while this is formal in nature, that we're providing a lot of information, we're going to make this kind of informal. We're going to get right down to the ground on this and just dig in. So let me translate what this slide means. We're not your attorneys because of this presentation. We're not. So still consult with your own attorney. That's right. All right, so let's go right here. So what are we trying to do today? Well, we want to make sure that we equip you with proper information. Like we started at the beginning, you know, we've discovered that somehow people are getting information that's not quite correct regarding how they can transfer assets, how they can, what happens after they're gone, and all those kinds of things. We're here today to give you proper information. And on that point, as a matter of fact, I'm glad that Shabnam is here, of course, because she's right there in Massachusetts. And so she knows whatever special twists and turns there are in Massachusetts law, she has that right there. And so we're going to make sure it's not only right generally, but it's right for your state. So in addition to that, we're going to point you in the right direction with this information. And we hope to inspire you to action. As you'll see in a few slides, a lot of people have not yet taken steps in this direction, and we're doing everything that we can to help make sure you do that. And so that's where we are. As promised, here is our first poll. So if you all could just answer this question, Chap, go ahead and explain.
Which answer best describes your family situation? A, financial wealth has passed through generations. B, assets have been inherited, but no true wealth, so no true money. Or C, no assets or no wealth has been inherited at all. So if you guys can take a moment and choose between A, B, or C, that would be great.
Remember, you go to tgqlaw.participo.com if you have not yet done that, and we see the results coming in. You can see in the bottom right corner, we have a few people who've answered, and we know there are many more who are on. So if y'all could just select which one of these apply to you, and then we're going to move forward. We'll take in a few more, and then we'll see.
And I believe, Terrence, just one thing. I just also believe, Terrence, that you had said it's best to be able to do the poll from a different device than you're using. So you guys, if you have a separate iPad or your cell phone, definitely use that as opposed to the device that you're using right now to be able to take the poll. It'll be maybe much easier. And again, right above the survey is the information. Again, it's tgqlaw.participoll, participoll.com, especially for those that are live on Facebook.
Yep. We are going, looks like we're sitting at this number a little bit. So let's just see. Okay.
It's still moving. Let's give them another second. And again, assets. Yep, assets could be property. It could be business assets, financial wealth, could be life insurance policies, money, it could be any of those sorts of things. These answers. So still going.
And all the answers are anonymous, you guys. It's not going to be synonymous with your name. Your name's not going to show up. We're just trying to get an idea about where everybody is at to be able to drive the presentation. Okay.
Policies, money, could be any of those sorts of things. These answers. So still going.
And all the answers are anonymous, you guys. It's not going to be synonymous with your name. Your name's not going to show up. We're just trying to get an idea about where everybody is at to be able to drive the presentation. Okay.
Any of those sorts of things.
Let's just move forward with it and let's look at these results. They're still coming in, but there will be more polls to be taken. So let's see what these results are looking like right now. Well, we see that 68% of the people who responded said that no assets or wealth have been inherited at all. And then that other 32%, has answered in a similar fashion. So, it's, let me go back to that for a second. It's, Shad, when you see this, what are you thinking? When you see these results, how do you respond to that?
When you see this, you're thinking either A, whoever was before us, they didn't even know how to pass on these assets, for one. So the question is, did they have wealth and for some reason it didn't pass on properly, or B, they just didn't create that wealth, which is also why we're here, to talk about how we can go about creating that wealth.
Yeah, and more results are still coming in, but let's
So,
move on to the next slide here. So what do you think about this here, Shab?
there was a study done in 2017 by the Economic Policy Institute. It says that white families are twice as likely to leave an inheritance than Black families. That's 3 times as large. As you can see by the chart, it's substantial. It's a big difference. And there's things to be done about this. So we have to definitely be mindful of these stats, these numbers.
Yeah. This is not surprising to me, although it's problematic to me. Why is it?
Yeah.
Why is it that white families are twice as likely, and why is it that what they're leaving is 3 times as large? What are we missing, or what are we not doing? And the bigger question is probably why. That's probably the bigger question. Whatever the case is, we know that this has to change.
And
right?
It's also, what don't we know?
Yeah.
Because a lot of it has to do with the fact that we don't know maybe what to do.
Yeah. And so that's one of the benefits of this kind of opportunity that you all are on right now, to get information so that you can know what to do. So the point is, we got to change this. We have to figure out, how can we change these numbers, change these statistics? Not trying to change what white families are doing, but definitely trying to change what the Black families are doing. We have, and the people of color in general, not just Black families. We have to make sure we get the proper information, put it in place, and then move it. As we were talking, Shab and I realized that we came up with 2 major components of this change. The first one is raising the bar. We got to raise the bar. And then the second is, we have to properly direct the bar. Shab, when you think about when we talk about raising the bar, that's an acronym for business assets, accounts, real property and personal property, as well as retirement assets, including life insurance. We think it's very important for people to consider and properly set up and operate businesses. Business ownership is one major way that you can create wealth, as well as leave wealth on to the next generations. I mean, that's how wealth has typically transferred over the years. And a lot of these other ideas that are on this page are baked into a business in some form or fashion. So building a business, getting proper advice on how to do so, and then running it correctly, I think is super important. That's one way. When we talk about accounts, we're dealing with checking accounts, savings accounts, money markets, all of that. This is a way to put your coins away so that they can grow, so that they can be there, because you're saving, so that you start building, so that there's something there for you to leave over to the next generation. Now, Shabin, in addition to the estate planning that you do a lot of property work as well. What are you seeing that people are doing with real property and personal property?
So one of the ways people are able to promote wealth is they're taking their real estate and they're putting it in LLCs, which is a limited liability company, or in trust. There's a lot of different forms of entities you can put your property in, but they're doing this so that they can secure that the property is outside of themselves. The property can keep on going through whoever it is that they designate forever. Like, it doesn't have to end with them. And they can prepare, the proper documents in order to really control what happens to the property, to navigate, where the property ends up and who it goes to, and what's to be done. So that's with real estate. That could be with commercial properties, residential commercial properties. And it's also with, as Terrence said, businesses. And it's another form of estate planning, is business planning. And it's really defining where and how you want your business to run and succeed, and what happens after you die.
Yeah, that's right. Of course, a major way of building wealth and leaving wealth is through the use of retirement assets, whether they're tax deferred assets like a traditional IRA or a 401k, 403b, 457. Many times your company that you're working for will match what you're putting in there, and that's a significant way to leave to create wealth, but also to leave it as well. One of my favorite tools that a lot of people use is life insurance policies. And there are different types of policies. And we're not spending too much time on this slide because we know that through this series, Building Black Wealth series, there are going to be other experts coming on talking about these things, including Michelle, who's one of those who can certainly speak to this. But between those retirement assets, life insurance policies, and things along those lines, significant wealth can be left to the next generation, because you've been building it. One of the reasons why life insurance is one of my favorites is because it can be an inexpensive way to leave significant wealth on to the next generation. So something like
Absolutely.
that combination of what you see on the screen gets you in the direction of building and creating that wealth. One thing I will say before we move on is that I think it's important to find somebody who's an expert in these areas, somebody who this is what they do for a living, to come alongside you, to aid you, support you, maybe direct you in building this wealth, so that as we move to the next slide, you'll have something to leave when we move to
right.
Yeah. Let's move to the next slide. The second thing that we talked about is directing that bar. As we're trying to change these statistics, trying to make sure that that people, including people of color, are creating wealth and leaving it, it's crucial that you make sure you leave it correctly. Sometimes people think they have the right thing in place, but they learn quickly, or at least their family learns later on, that may not be the case. So you got to make sure you spend time properly directing the bar, which is the scope of the remaining portions of this presentation. Now, we're going to do another poll as we launch into the remainder of this presentation. So go right now, if you can, to tgqlaw.participole.com on your mobile device or computer. And if you can, just take this poll. Shab, go ahead and give it, explain what we're doing here.
So which answer best describes your current opinion? So maybe not what you currently have, but your current opinion. A, all I need is a simple will. B, my plan should include a complete trust. Or C, I don't really need a will or a trust.
Yeah, so when we're talking about how, what your plan should look like, how will you leave that generational wealth on? What's important to have? If you weren't here, how would your stuff get to somebody else? What's your opinion? Which of these is the best way for that to happen? Okay, they're coming in now.
And if some of you guys don't understand what a will is or what a trust is, those things will be answered this evening, because there are many types of wills. Again, these guys are the experts that can explain that. I don't know if we're going to go a deep dive into that. And also there are different types of trust. But again, this is the time. If you're on Facebook Live, definitely feel free. Denisha is monitoring that. Feel free to pop in your questions. Also, please, you can type them into the chat box. We have, along the chat box, we have the poll that's there. I believe Denisha just added it in. I also added it in about a few minutes ago. Again, go to tgqlaw.participole. That's PARTICIPOLL.com to be able to participate in the survey. Thank you.
I think we should go ahead and show these results. It's actually surprising to me, but I'm gonna let you comment on it first. So, as we look at these results, let's see if we can get them here on the screen.
Oh,
yeah.
Okay, that is very surprising. So as you can see, a lot of the people who responded believes that they should have a trust, which is awesome. It's awesome.
Yeah, we'll explain why as this presentation goes. That's pretty surprising. I may come back to it later and explain why it was so surprising.
Yeah, well, Terrence, that's because everybody wants to be a trust fund baby too. So.
Well, hey,
you got to start from somewhere, right?
That's right. That's right. You got to start somewhere. So this one's good. This will be real good. All right. So when we get into this topic, when we get into how to leave things and what should you do and all of that, all of this really focuses on two specific questions. In my opinion, these two questions are two of the four most important questions I think that everybody will deal with in one way or another in their lifetime. I believe it's the third and fourth most important question you'll ever deal with. So out of those two questions, let's look at the first one. It's pretty simple. And as you look at this question, I want you to think about this for yourself. Right now, don't think about your mom or your cousin or your brother or anything like that. think about this for yourself and really answer it. This is maybe the only slide that may be hard to really look at for now. What would happen to your assets and or your children if you passed? I mean, like literally, if you were not here tomorrow, I know we don't like to think about it, but just hang with us for a second because it's important to. If you were not here tomorrow, what would really happen to your stuff or to your family? As you'll see, most people can't answer this question confidently because they don't know for sure. And that's the problem. We got to fix that. We have to fix that. And that's the purpose of this presentation today. Second question is pretty similar. A lot of people think that this work only deals with what happens after you're gone. But there's another part of life that we have to plan for. And that's question number 2. If you could no longer make decisions for yourself. And think about this for you. If tomorrow you woke up and you didn't realize that you woke up, or tomorrow you were up and you did realize it, but you couldn't talk or communicate. I'm sure we all know someone who's been in this situation. If it was you tomorrow, who would be able to make decisions for you, and what decisions would they make? I truly believe, because I now see this stuff in action on a daily basis. I get the call when somebody has passed or somebody has had a stroke or whatever it is. I get the call from the family members. I truly believe at my core that these are 2 of the 4 most important questions that you will ever deal with in one way or another in your lifetime. And so to me, it seems like the wise person fixes this now so they know for sure what will happen to their assets because they've planned correctly, what will happen with their children, and maybe more importantly, what will happen with them if their health fails. Hard subject, I know, so let's move on. But
and not to forget what will happen to your pets. There's a lot of people who are pet people.
That's right. That's
pet
right.
trusts are real.
That's right. When I was learning how to do this workshop, and I don't know if I've ever told you this, when I was being trained in this years ago, I was at a workshop one day and they started talking about pet trust. And I thought that was an acronym for something because I just, I'm like, we're at this big time conference and talking about pet trust. This has to be an acronym. No, they were talking about putting a trust together that talks about what happens with your pet and what assets are left for the benefit of your pet after you're gone. And it makes total sense to me.
Yeah. I have 2 words for you, Leona Helmsley. And if you guys don't know who that is, Google it. And that's all that I'm going to say on that matter.
That's right. That's right. That's exactly right. So, Shab, why don't you go through this slide? This is eye-opening to me every time I look at this.
Yeah. 60% of American adults have no will, trust, or power of attorney. 60%. Less than 20% of millennials, 18 to 34, have a plan. Less than 20. And these are the people who are probably just, starting their career, maybe buying their first home, etc. No plan. 34% of adults, so that's ages 35 to 44, they have a plan. 39% of adults, 45 to 54, have a plan. And 66% of adults, 65 plus, have a plan. And that's obviously they're thinking about the next step for them, right? Retirement, et cetera, et cetera.
Yeah, when we look at this slide, one thing that comes to mind for me, it's exciting. And I'm actually thrilled to see that 66% of adults that are retirement age do have a plan in place. But then I thought about it one day when I saw that. And I said, if my son came home with a 66% on any test that he took in school,
right,
I wouldn't be too happy about that. Even though that's not technically failing, this is still a problem. Only 66% of people have put a plan in place that answers those 2 questions on the last slide. We got to fix that. We got to
and then and it brings up the other thing too. It's like, all right, so we know that your output's only as good as your input. The question is who are they surveying? Looking at those numbers, is it just so they have Americans, but how many of those Americans are people of color? That they put in there. So I'm pretty sure those numbers will be very different, very different.
Yeah,
absolutely.
Right. That's right. So time for another poll. So we're going to run through quickly. So answer quickly, you all. We're going to run through these 3 polls quickly. Go ahead, Shab.
Have you completed your own will or trust plan? So it could be one or the other, both, something you think is an estate plan.
Yeah, they're coming in. They're coming in.
Yep. So again, tgqlaw.participole.com to vote. tgqlaw.participole, PARTICIPOLL.com. Again, it's best that you do it on a separate device to get the poll. But thank you for everybody for participating. And again, it's anonymous.
Yeah. And we're going to move on because this one is 2 more in a row. We're going to go through them kind of quickly.
All right.
We can see the results, but remember, we cannot see who's sending anything. We just see the graph before you do. That's it. Got 30 people. Let's go. Let's go with that. And let's see what these results look like. Uh-oh. Shabnam, what do you think?
Oh, okay. This is more what I predicted. And this is real. And even if you ask the people with a plan, even if you ask your friends and family if they have plans, you will find that the majority of the answer is no. Either they're thinking about it, doing it one day, or they just haven't gotten to it. But this is, I feel, a true reflection of our community.
There is. Let's look at this next slide. If out of the few of you that said yes, has your plan been reviewed by an estate planning attorney in the last 3 years? Just yes or no, really quickly. We're going to move on past this one.
I imagine this will be a smaller number.
And again, thank you everybody for typing in your questions in the chat box. Please continue to do that. We will be answering questions at the end. But if you have questions, feel free. Again, if you're on Facebook, Denisha is monitoring those questions there. For those of you that are on Facebook Live, and for those that are here with us on Zoom, pop in those questions, in the chat box. Welcome, Britt. I did see you kind of pop in as well. So I'm glad that you're here this evening.
Yep, and don't worry, you all. After this next one that we're doing, there won't be another poll for a while. So don't worry. Don't worry. These answers are not surprising to me. Shabnam, what do you think about this? 78%.
Yeah, not surprising. Most people, they prepare it and then they forget about it, which is fine to do unless something changed. So you always need to review your will or your trust or your estate documents because things are always changing, especially depending on when you started your estate plan.
That's right. That last thing that Shabnam said, I try to scream from the mountaintops. It's right. If nothing changes at all, no need to. However, things change all the time. I typically review plans with my clients every year. Every year I touch bases, and I started doing that a few years ago because when I would meet with them, there's something they wanted to change, or there would be a change in the law where we needed to tweak it and update it. So I do an annual review with my clients, kind of like a doctor's checkup. In almost every meeting, people have something that they want to change. This is an active, living, moving, breathing plan that you're putting together. Last slide as promised. Why not? You can just type in a quick response in that section provided on your polling.
So this is for all the people who responded was no, they don't have an estate plan. Why not? What is stopping you from having your plan?
And if you do have a plan and it has not been reviewed, why not? So just throw in here whatever your response is to that. People are typing. Okay, these are good answers coming in. Makes sense to me.
Thank you, everybody, for participating. That helps. Again, all this feedback is great, especially if we have these guys back. And then feel free to comment if you feel that this information is valuable. It's, we'd like to have that feedback because you never know. We like to have them again. Could be sooner rather than later. Please feel free to even type in comments if you're enjoying the information, if it's valuable. And it's also to continue to send your questions through the Facebook Live and through the chat.
Yeah, we're at 20. Let's go ahead and show these now. Let's go ahead and show these different responses, and all of these that I'm seeing um, are common answers that I've seen over and over and over, except COVID stopped the process, because that's so very recent. Um, and even with that, I would still push whatever about COVID stopped the process. I would still push to get it done. You know, a lot of the
Yes.
that I'm talking to, what we're doing is we're meeting virtually with people, and we haven't, you know, I mean, we're in Michigan, so we can't. You're not in Michigan. Shapman can, of course, if you're in Massachusetts. We're meeting virtually, and we're meeting with
Yeah.
people, and the process has worked out. Chap, that's
Yeah,
what you.
we sure are. We're meeting virtually. And, you know, we also schedule, depending on who it is, in person, car, drive-bys. Like, there's so many ways to get this done that COVID, yes, maybe in March, it put a stop to it, but we have, you know, figured out how to get this done because this is very important. So this is
Yeah.
not something that we can delay, especially because of COVID.
And I just want to thank three people in the middle for your open, you know, honesty, transparency here, even though we don't know who you are, where you said never was taught to me, hasn't been a priority, and procrastination. I appreciate that, because truthfully, for most people, as I'm finding it, those are the reasons why they don't do it. And they don't know how. I saw that on here as well.
Yeah.
We get that. And that's why we're glad that you're on this presentation today, so that you can get the information. We're going to push you. This presentation is going to, we don't see you. We don't have your phone number. We are going to push you in this presentation anyway, because we're the ones who we see what's happening when you pass or become incapacitated, and you do not want to visit either one of those life situations without having the right kind of plan in place. It's not a fun process for those who have to deal with it.
And the other one on here, though, before you move on, is nothing to leave. A lot of people have that misconception that I don't own property, or I don't have hundreds of $1,000s in the bank, so I don't need an estate plan. But what you will learn is that, especially like with a trust or even a will, you don't know at the time of your death what you will have. And you can fund, you don't have to fund these things when you prepare them. So you can have it ready for when that wealth comes to you, because we all are getting this wealth at some point, because this is what we put in the universe, you know, will be ready. So you don't need the wealth or the things or the property or whatever to create your estate plan today.
Right.
That's right. You never know what you'll have when it's time for it to be distributed. Somebody could have left you something. So we never know. Let's jump right into this presentation. We've been doing polls and all that. Let's get to the meat. Let's get to the meat of the presentation. What we're going to do here, we don't sit here and just talk to you about what's the trust, what are wills, what are powers of attorney. You'll get that information before we're done. Instead, we want to show you the why of all of that.
Yes.
To provide you with scenarios that we've seen. These are real life scenarios. And we're going to let you know how we respond to them, what we think. And let's just see where that goes. Shap, I'm going to give it to you.
Okay. All right. So this is Stacy's dad. This is Stacy's dad over here. So Stacy's dad was told that state laws have determined distribution of his assets upon death. He often says, I don't need to waste money planning at this point. Hire an attorney. Is this the right or the wrong way?
Yeah. And you know, this is a very common situation. People believe that when they're gone, things are going to go, you know, where they want them to go. For example, in this case, this is Stacy's dad saying, hey, I learned, somebody told me that according to state intestacy laws, good word to remember, that means you pass without a plan in place, without a will. He says state laws say that if I pass without a plan in place, that all my stuff is going to go to my daughter, Stacy, because I'm not married. So why should I waste money putting a plan together that says give it to Stacy when Massachusetts law is already going to give it to Stacy? Kind of makes sense. Of course, until you talk to us. Here's why we think that's a bad idea. First of all, Stacy goes to probate court. And I have time, cost, and publicity here. Let me talk about it a little bit. So in what we do here in Michigan, and Chapman and I have talked, and it's fairly similar in Massachusetts as well. Without a plan in place, certainly things will go to your heirs if there's anything left over after the probate court process is over. So Stacy is the one who, after you're gone, is going to be going to court, trying to figure out which documents to file, trying to meet all the deadlines on time, trying to handle all that business while she's hopefully mourning your death. And she's going to be the one responsible for doing all of that. And when we think about probate court, there are three components of it that you have to consider. The first is time, cost, and publicity, second and third. We talk about time. Probate court typically has to take pretty much by rule somewhere around 6 months before everything can really be distributed for a regular general estate. If people fuss and fight and argue, it's going to take much longer than that. On average, in my opinion, it takes about a year to get through that process completely if there are general assets involved. We talk about costs. Depending on where you are, the costs can vary. So there's certainly filing fees, which typically are around $300, somewhere around there. And Shamini, is that pretty similar in Massachusetts?
400 in Mass.
Okay, so
400 to start.
Yeah,
not including publication and filing for inventories and counting and ascents and everything else.
Yeah. So you have that cost as well. And then attorney fees right now, depending on who you're using, and hopefully you're using somebody who knows what they're doing, they're going to charge you anywhere, I would say, between $2,000 and $6,000 for a probate case. And if there's arguments, fussing, and fighting, and more court involvement, it's going to go up into 5 figures pretty easily. Is that what you're saying as well, Chapman?
Yep, absolutely.
Yeah.
And as far as time, it really depends on what county you're in Massachusetts. So if anyone had any dealings with Suffolk, for example, you're going to be in court for, if there's any contesting, for 2 years or more. It's not a 6 months to a year process.
Wow.
Only if everything goes smooth, all the assents are in, maybe 6 months to a year. But even that, it's timely, especially if you have the property that you need something, to transfer, refinance, or whatever.
Yeah.
Shabnam, and you said Suffolk, meaning Suffolk County here, and
Suffolk County.
Because that's all. And for you guys that are tuning in, especially if you're in Boston, Suffolk County, what's that? Dorchester, Roxbury, Mattapan,
East Boston, Dorchester. Yep. And then you have Plymouth County, which is as bad as Suffolk, which is the Brocktons, for all the Brockton people on the call. And then Plymouth and Bridgewater, down that way.
Yeah.
Okay. Question. Hi, everyone. So you say there's a lot of time involved and there's a lot, potentially a lot of court and marketing. Where does this money come from for all of this? Because I know there's a cost with all of what you're saying right now.
Great question. You want to take it, Chapman?
So the cost comes from the estate. And this is what Terrence was talking about, that, after that's taken care of, if there's anything left, it passes to you. So if there's money in the estate, it comes from the estate. If there's no money in the estate, or a little bit of money in the estate, usually the personal representative or the heir has to front the cost, and they may not get paid back depending on the estate.
That's right.
And the question is, why would someone without money in the estate probate it? Usually there's an asset involved that it needs to be probated for them to have any say.
Like a property. The only thing there is a house, and you want to keep the house. So you're not selling the house and turning it into money. You want to keep the house, but you have to go through probate court because things weren't handled correctly ahead of time. Somebody's going to have to put up the money for all of these fees so that you can get that house. And hopefully you'll get it after the other costs that are associated. Because the other thing that has to happen is there's this publicity factor. And the Aretha Franklin case, which is right here in my backyard, is a great example of this issue. I did not personally know Miss Franklin. I loved her music and still do, but I didn't know her personally. But I have to imagine that she would not have wanted all of her business in the street like it is. Everybody in the country knows that there's complete chaos. At least that's how the media is portraying it. Complete chaos in that case. And why do we know that? Because anybody and everybody could go to the Oakland County Probate Court in Pontiac, Michigan. They can pull her file. They can find out all about her family. They can find out all the assets that she had. They can find out all the debt that she had because it's completely public. So if you're okay with your business being in the street like that, then maybe you're okay going through probate court. If you don't want that to happen, then probate court is not where you want your family after you're gone. Maybe the biggest problem of all, though, with not having the right kind of will in place is that no, in Stacy's dad's case, nobody knows what he wanted. Maybe he didn't want it all to go to Stacy. Maybe he wanted some of it to go to a charity or a church. I have a client who the only family she had left was a brother who was special needs and her cat, Esther, talking about pet trusts and things. And she wanted about 90% of her estate to go to several ministries, televangelists, churches, and things. She wanted about 5% of what was left to go to her brother, and she wanted the rest of it to go to her cat. Well, that wouldn't happen if she didn't have that written. It would all go to her brother, and then that would create a problem because he needs governmental support. He'd be disqualified because of that. This is why you have to go to a specialist in this area and help them craft your plan, because you never know how something about your story, and everybody's story is different, might send it in the wrong direction if you don't plan correctly. Let's jump on over here.
And you guys, and again, just really quick, you know, again, we have Shabnam and Terrence here, given just expertise, just a huge, you know, applause, you know, for them for being here, taking time out of their schedule to pay it forward, to share with us. And the bottom line is that they're talking about being proactive, right, guys? I mean, it's all about being proactive, not reactive. When you're reactive, it's going to cost more headache, more aggravation, and more money. Okay, this is what we provide here at the Building Black Wealth series. We're looking to give you the knowledge ahead of time, because again, this whole series from the time that we began is all about wealth building, not living hand to mouth. So we're talking about investing, we're talking about many different things. We're always talking about the wealth building, but we need this component here to preserve our wealth so we can pass it down. We're always throwing that word about generational wealth. This is how you secure all of that wealth so you can pass it down, and that it doesn't get caught up in what's happening according to your county or your state. So please definitely take heed to what they're saying. The bottom line is to put these things in place when you're on your wealth building journey. You're just like laying down the foundation. So continue, please. Thank you.
That's right. Let's look at the second scenario. Shabnam, what do we have here?
We have our blended families. George and Gertrude were married later in life after previous marriages. They have 5 adult children between them. Gertrude thinks that a trust may be the best way to divide assets between their children. Is she right?
Just like the Brady Bunch, right? No children together. What happens when they're gone? Like, what's the best way to make sure things are going to go the correct way? Gertrude seems to think that it's, by having a trust prepared. And the question is, do you think she's right? Now, when we do these in person, we ask you to raise your hand and we kind of poll you live. We're not doing that now. We're going to just give you our answers. She's correct. The trust is a good idea in this situation. It's not the only thing that can work, but it certainly will work if it's drafted correctly. Trust can keep assets out of probate court. This is where I like to tell a story about an actual client of mine that I had. This is back when I first got started doing this kind of law, several years before I even started my own law firm. And George and Gertrude came in. Of course, that's not their names. They came into my office. They sat down at my desk and they said, "Attorney Quinn, we need some help. We need to put a plan in place." I said, "Okay, well, thank you. I'm glad that you came. Well, so what is it that you're hoping to do?" And it was one of those situations where they were older, not old, but they were older. They were in their 70s. They both had been retired for years. She had built a big business, a daycare, in her retirement. He was just, he worked out back in overalls, and he came in for dinner when dinner was ready, as that kind of scenario. Well, the wife, Gertrude, did all of the talking in this meeting. And she sat down and she said, "Attorney Quinn, listen, you got to know something right from the beginning. We need to do a plan. And right from the top, what you got to know is that we don't like our children." That for a second, I was kind of like, wow, that's kind of deep. Now, I didn't show that on my face, but inside I was thinking, wow, it's like that, huh? She said, "We don't like our children, not at all." And she said, and we don't want any of our stuff to go to our children at all. And they had built a nice estate. They had plenty of cars. They had property in North Carolina and in Michigan and in Canada. They had, just all kinds of things, a lot of money and all of that. And he said, we want everything instead to go to our grandchildren, but we don't want it to touch our kids' hands because we just don't do that. And she looked at me and she leaned forward and she said, and not over my dead body can anything go to his daughter. And I said, oh, here we go. I don't want anything to go to his daughter for sure. None of the kids, but certainly not his daughter. And she looked at him and she said, ain't that right? And he said, mm-hmm. And that's all I heard him say up at that point. Now we went back and forth trying to figure out a plan. And she had to get up to go take a call or go to the restroom or something. And I wanted to at least hear his voice. And I said, so George, Mr. George, I said, this is what you want? You don't want anything to go to your children, everything to your grandkids? And I hadn't heard him say anything yet. And he said, yeah, she's right. We don't really like our children that much. And we don't want them to do anything. We want everything to go to our grandchildren. But the reason she's so upset with my daughter is because when I was in the hospital, my daughter never came to visit me. And my wife saw how much that hurt me. And ever since then, they just haven't had a good relationship. So I got it at that point. Well, the wife came back in because he had said before she came back, he said, I want to give her something, $1,000 or something. We were talking back and forth about what's possible, one car. He wanted to leave her something. The wife came back in and she said, no, absolutely not. Don't leave her anything, not over my dead body. I don't care what this man is talking about. I don't want to leave her anything. And they couldn't agree. Well, time passed, a couple of weeks passed, and they called me and they said, we changed our mind. We just don't want to do anything. We can't agree on anything because he wants to give her something and I refuse. And they wanted to stop the whole process. So I sent them a letter that basically said, well, I want to give you a little bit of a scenario here. Did you know, Mrs. Client, let's say that you passed first. All of your assets will go to your husband because they're his already. So they're all going to stay with him. And then guess what happens when he passes if you don't have a plan in place? And the letter went on to say, it all goes to his children. So first of all, it goes to the wrong level of kids that you said where you didn't want it to go. But secondly, it's all going to go to the one person out of everybody that you said not over your dead body. And that was his daughter. And the reason is because typically, even from state to state, there's some kind of arrangement that says the majority, if not all, of the assets will go to the spouse of the person who passed. And then when that person passes, it goes to their kids, which then means her kids wouldn't get anything, which she didn't want, but some people would want it to happen that way. And everything would go where she didn't want it to go. Shabna, do you have anything to add to that? What are your, when you think about that scenario, what are your thoughts, or is there something different that goes on?
And you also have to think that there are times when your prior spouse, your ex-spouse, have minor children, and you may want that spouse to have something. And their rights in Massachusetts is automatically terminated when you remarry. So you have to take into consideration things that you may want to happen that is automatic in Mass if you don't enter it into your new plan.
Shabnam, can you repeat that one more time, please? Because that's huge. Repeat that one more time.
Yeah. So you have to make sure that the things that automatically terminate, one of the things is if you remarry, everything that your will, your estate plan terminates at that divorce. So if you want anything to go to your prior marriage spouse for their children, for your children, but you want it to be in the name of your prior spouse, you want to make sure something like that is in your will. And if you're just counting on the laws, the density laws, then they will automatically be pushed aside and your new spouse will receive their share. So in Massachusetts, don't quote me, it is a half, and the first 100,000 goes to your spouse and the rest will be split among your children. As of right now, I think that's what it is, or a fourth, and then the first 100,000. So it's
bottom line, a lot.
A lot. A lot. Exactly.
Bottom line, a lot, y'all. Again, this is why it's good to have these things in place, everybody, especially when you're, we joke around that, sometimes business, marriage is a business. And the things is just like business has rules and protocol. Listen, y'all, anybody out there that's engaged, please take heed to this information and get your stuff correct, especially or if you're on your second on your second marriage, okay? Definitely go back, because I mean, we'll talk about some other things at the end. Want to let these guys get through the content, but that was just powerful what she said. Look at all the comments coming in now in the chat box. See, done lit a fire.
That's what we like.
One thing to keep in mind with this, though, is also with your, in that scenario that Chapman just mentioned, when we talk about beneficiary designation. So if you have a beneficiary listed on life insurance, retirement asset, or something like that, that probably won't change like that.
Yeah.
So update those beneficiaries.
Yep.
You'll have a former spouse on there. There's a very good chance and probably a likelihood that that asset is going to go there. The answer to all of this is you have to connect with an estate planning attorney like Shabnam Mashami, who's in Massachusetts, so that she can walk you through all of these steps. She's going to help you turn those stones over so that you can make sure all of that is corrected and updated, taken care of correctly. It's highly important. And the more we get into these scenarios, you see why we're saying these two questions at the beginning are two of the four most important that you'll ever deal with. You got to deal with these right now. You got to deal with them right now. Let's move on to the next one. This is the third scenario. Now, this one gets really fun. Go ahead, Shannon.
All right. Joint ownership of assets. Doug's mom added him to her bank account. He listed Doug on her property for convenience. When she dies, Doug will automatically receive both. So we have the bank account and the property. He also is the beneficiary of her life insurance and 401k. This arrangement is sufficient. Is this right or wrong?
So the reason, I'm just going to pull the curtain back. The reason that we put this slide here is because this is a very controversial topic. What we already know is that about half of the people watching this right now are in this situation in one form or another. You've added your daughter to your account so that you can send her money in college or whatever it is. It's easy for her to get it out of that account because there's a bank wherever she is. Or you're on your brother's account or your dad's account so that you can handle business for them and just, pay the bills and take care of all of that for them. The question is this okay? And I can tell you, it makes complete sense to me until you talk to the lawyers. I think this is a very, very, very bad situation. The reason is, first of all, Doug can take all those assets. When you add somebody to an asset of yours as a joint owner, they're just that. They are a joint owner. Now, I'm not talking about beneficiary designations. That's fine. That can work. Not talking about that. We're talking about adding them as a joint owner on your bank account or on your house. Matter of fact, let's talk about Charlie. So when I used to do these presentations early in my career, the guy who trained me used to do these with me. And he would tell a story about a client of his named Charlie, who was super wealthy. He had property in Michigan and in Florida and just all over the place. His daughter ended up going to college down in Florida. And for state tuition purposes, he added her name to his house, his property that he had down there, so she could get in-state tuition. Well, things were great until daughter met boyfriend. And boyfriend started causing daughter or helping daughter do bad stuff on Charlie's property. Well, Charlie didn't like it. And Charlie called daughter and he said, daughter, you got to get out of there. You can't, this isn't happening like this. You got to quit doing that stuff on my property. And daughter said, well, Dad, I'm grown. I'm 18. I can do whatever I want to on my property. He said, well, I'll tell you what I'm doing. Monday morning, I'm going down. I'm going to get in touch with the county. I'm going to have my attorneys down there create a deed, and we're going to take your name off of my property. And she said, Dad, I'm the only one who can take my name off of my property. And that's because when you add somebody as a joint owner, they're just that. They are a 100% owner, just like you are. So although we always add the good child to the account, we don't ever add the bad child. We probably won't take your money in your bank or anything like that. We always do that. If they decided to be a bad child, they could take all the stuff out of that account. Now, courts around the country, certainly here in Michigan, are starting to rule on this in a way where it says that depending on the intentions at the beginning, and how do you prove that, which is the problem, depending on your intentions when you added them, determines whether or not they really had the right to take it. But do you want to have to go to court to prove that and spend all that money to prove
A
that?
lot of money. It's a lot of money to prove that because intention is hard to prove.
That's right. Very hard to prove. So Charlie was in a tight spot, and so are you if you decide to add somebody as a joint owner. But that's not even the biggest problem. The bigger problem is this. Doug's creditors can take. Let's say Doug would never take your money and never do anything bad. Doug is the good child. But Doug had a mistake. He didn't pay his taxes one year, or he got in a car accident and owed somebody money. And now that creditor is suing Doug and wins, finds out where Doug has assets, including this account that you added his name to. And now that creditor can come into your account and take your money. That was not your intention. But when you make somebody a joint owner, that's what you're doing. Right about here is where I always say, I always recommend to people, never, ever, ever add anybody, and this is worth writing down, never, ever, ever add anybody to any asset of yours as a joint owner other than a spouse, maybe. Let me say it one more time. Never, ever, ever add anybody to any asset of yours as a joint owner other than a spouse, maybe. Now, in my case, my wife is on all of my stuff, so I'm not speaking against doing that. That's my setup. But my kids won't be, and I love them, and they're cute too. They won't be added to anything. I'm not adding my mom. I love my mom and my dad big time. I'm not adding them to they can't be on my accounts. I encourage you to take that same approach. It's way too risky, and there's a better way. All right, let's look.
And also, just one thing to add to that, you have to remember, especially with accounts, it really depends on what you want. So if you have a joint account, meaning two people are just listed as owners of this account, when one person dies, 50% goes to that estate and 50% goes to this person. So if that's not what you intended, you need to make that clear.
And that may be,
right.
That's probably a Massachusetts difference, because here, if they're added as a joint owner with rights of survivorship, they get
rights of, that's true. Here too, rights of survivorship. But if it doesn't have those words, rights of survivorship, then it doesn't.
Right. Yeah. Thank you for clarifying that, because I was going to step in on as a finance person and make that designation, you guys. So tenants in common versus rights with rights survivorship. So definitely you guys that have joint accounts, maybe with your parents or siblings or whatever, definitely make sure you get that that designation. Again, we're going to cover this stuff at the end. That's why I'm being quiet. I'm just making some notes on all your questions that are being asked. So definitely, again, if you're on Facebook Live, Denisha is monitoring that. Please feel free to zip those questions over. And also I'm writing down all the questions that are here. We want to be able to get through the content, so we have the time, the quality time to answer your questions. So go ahead.
Yeah. So the bottom line is, you really want to see an estate planning attorney, and we're not, I promise, we're not saying this just trying to get your business. We're talking about this from the problems that we have to work people out of, and we're giving you the information ahead of time so you don't see that problem. You want to find somebody who specializes in this area, not a general practitioner, somebody who specializes, so they can look at your situation. They can let you know if it makes sense to add a joint owner, which almost always the answer is going to be no, other than a spouse. And they can show you a better way to accomplish what you're hoping to accomplish by adding a joint owner. There's a better way than that, and we'll get into that. Real quick, Shannon, I'm going to let you kind of do this one. This is, we were talking, and this was something that you were seeing a lot of. We're going to come back to Stacy's dad, who didn't do a plan. He said he wanted to just let state laws deal with it, and he left state. Everything's going to Stacy. What's happening here? What's happening?
Okay, so remember, Stacy's dad, no plan. He doesn't need one. He was cared for. So this is where this changes a little bit. So Stacy's dad was actually cared for by Jason, his nephew. Jason lived with him in his home for 10 years. Okay, 10 years, took care of Stacy's dad, took him to his appointments, took care of the house, took care of the roof issues, the yard, everything for 10 years. Stacy and Jason, they're not friends. They don't get along. They're cousins, but they don't get along. They don't speak. Stacy's dad passed away 2 months ago. There's a house and a bank account. Those are his only 2 assets. Okay. Jason believes the house should be his since he cared for and lived in the house with Stacy's dad.
Stacy's been gone all this time, hasn't been helping at all or any of that
We
kind
haven't
of
heard.
stuff.
We haven't heard from Stacy
at all.
Is he right? Is he right? Should he get the house? 10 years taking care of this property, managing the property, living in the property, taking care of Stacy's dad. Should he get the house?
That's a very good question. I think he thinks so.
That's an awesome question. And I'm pretty sure you guys see that a lot. I know on the financial planning side, I see it. A lot of people have this air of entitlement, even though they haven't been around. Yeah, great question. Again, you guys, this is why we love having professionals here, especially that brings that value. I mean, this is awesome, you guys. Thank you.
Yeah. Let's see the answer. Let's see the answer. You all probably know the answers already. No. I'm gonna let you talk about this, Chap. I'm letting you.
Everybody's blowing up the chat box saying no.
Even though everyone's saying no, but we get this all the time. This is the biggest issue, I believe, in our community in Massachusetts. I am the nephew. I need this house transfer because if we have a leak in the roof and I need to refinance. Okay, did you probate this? Is there a will? No, but I've been living here for 25 years and it's mine. No, actually, we have to now go back and file a probate. And, you know, in Mass, there's this whole extended version of probate if you waited, if the person died pre-MUPC, and et cetera, et cetera. So now is drained out from being a 6-month to 1-year process to now a 5 years, depending on who's on the other side, what county you're in. And now this person is trying to refinance and they can't get out of it.
And let me throw something else in here, and then you can tell me if this is not the case in Mass. But I've had people very recently reach out to me about this. They're considering just keeping the house. They want to just keep making the payment on the mortgage, and they figure they're all good. And there are a couple of problems with that. And Shab, this is getting into your real estate work that you do as well.
Yep.
Directly where I'm wrong. But what they're doing is they're saying, I'm just going to start making this payment, and we should be able to live here, and it's all good. And I'm telling them there are at least 2 problems, if not many more. One problem is as soon as that mortgage company finds out that the person who had the mortgage is gone, they have a right and likely will call that mortgage due. They want their money.
Absolutely.
They didn't approve the kids to make the payment. They don't trust the kids. They don't know the kids yet. So they want their money, and they're going to likely require that you refinance if you can't come up with the money, that you refinance, which means you got to go through the whole credit thing and all of that. And so these people will say to me, well, I tell you what, I just won't tell him that he passed. Okay, well, we can try that. But the other problem, even before they discover it on their own, the other problem is homeowners insurance. These companies, insurance companies, are looking for reasons, and I'm not even saying it in a bad way, looking for not to pay out if the house burned down or the garage caught on fire, and then you file a claim, they're going to say, I don't know you. And they're going to pay that claim out. And so you can't even get the house You've probably been paying that homeowner's insurance policy all this time for nothing. You won't be able to get the home insured properly unless you're the owner of the home. Now, you're much more involved in real estate than I am, Shab. So
absolutely. You're absolutely correct. And you also have to remember when you try to claim those deductions on your tax returns, there's going to be a problem there. There's a problem with everything Terrence just mentioned that applies in Massachusetts. A lot of people try to just keep paying without saying anything, but they can call the note. It's that fear of being like calling the note at any moment is real.
Yeah.
So
let's move forward. We're coming to a close for the presentation. We want to get to your questions because we're seeing all kind of questions coming in, which is great. Make sure that at that tgqlaw.participate.com, you're loading your questions in there, because at the end, you're going to see, we're going to put each question up that we're answering on the screen, but we need you to put it through there in tgqlaw.participate.com for us to see that.
Yeah, and Denisha is also manning that as well, Terrence, behind the scenes. So we thank you, everybody. like I said, please submit your questions because they will be answered this evening.
Here are just a few additional things to think about. In our broader presentation, we would do more scenarios on these, but we're just going to talk about them now. Simply put, for most people end up feeling that a will by itself is insufficient. Now, this is after they talk to us. Prior to talking to us, most people think that a will is all that they need. And then they're shocked when they discover that if all you have is a will, you're probably promising your family that they are going through probate court. A will is nothing more than a letter to the court saying where your stuff should go after you're gone and who you want in charge of the probate case that's going to make sure that happens. Your will has no value without a probate court proceeding. I know you haven't heard that before. Some of you haven't, but that's absolutely true. Oftentimes people choose a trust instead, and we'll get into that on the next slide. Single parents of minors, sometimes the other parent is not friendly to you, or you all don't like each other, whatever it is. And not only don't you want the kids to go to the other parent if you were gone, but you certainly don't want your assets, that life insurance and all of that stuff that you left for the kids, to go to the other parent. And oftentimes, if the other parent gets custody of his or her child, which is likely to happen, that person may also end up being the person in charge of the money that you left those kids. So it's in their hands. Shab, is that how it's working in Mass?
Absolutely.
Yeah. Children with special needs, if your child is in a situation where he or she does need or may eventually need governmental support that's needs-based, and you end up leaving your assets to that child directly because you didn't do a plan and it passed through intestacy laws or other means, you are likely disqualifying that child from that governmental support. So if you go to an attorney who specializes in this area, he or she will be able to help you create a plan that allows you to take care of the child with your assets in a way that the government will allow them to continue receiving the governmental support as well. It's very important, very specific. You have to be very careful how you do that. And you definitely want to make sure that child is being taken care of. Rental property, I'm going to send that one to you, Shep.
Yep, so with rental properties, again, is what we talked about earlier, is just being able to protect those properties. If that's putting in an LLC or a trust, but it's really just protecting it from your personal liability. Yeah, and then we have the long-term care needs.
Yeah, and that's just if you end up needing nursing home care, which more and more people are needing because we're living longer. A lot of people think that the state will take your house. I haven't seen any lots that the state owns where they took people's homes because of Medicaid. That's not really what happens. But what does happen is you have to qualify, and qualifying usually means in most states that you can't have assets more than about $2,000. The number might change a little.
Very true.
That's what it is. Yep.
Yeah, and so there's special ways that they determine. There's some assets that they don't count the value of, like your home. Typically, you are allowed to have a home, and they won't count the value, and that's why the whole losing your house thing typically is not true. But other assets, there could be problems on the horizon if you try to give assets away so that you can qualify. You don't want to do that.
But it does become true when, two things. When you go into a nursing home, it will become true. They do look at that, and they will put a lien against your house. The Mass Health lien is very real in Massachusetts. And also, what was my second thought? Mass Health lien. And there's a 5-year look back statute in Massachusetts. So when we ask ourselves, do we wait to start an irrevocable trust, or should we do it now? Just remember, when you wait too long, Mass Health or Medicare, they can look back 5 years to see if you moved property into a trust or into anything. And if you did, they can still put a lien against your property.
Right, and you guys, and just so you know, Shabadan is talking about again, we're gonna probably address this a little bit later on with all the questions. But I just wanted to make a quick clarification. What she's talking about, because usually with long-term care facilities, there's self-pay, and then there's some that, that are Medicaid based, and you can't have assets. What she's addressing right now is the one that is Medicaid based. Am I correct in that, Shabnam? Okay.
Correct.
So self-pay is a whole other ball game.
Yeah.
Yeah. In Michigan, the going rate for a nursing home is about $8,000 a month. So if you can afford to pay that, then you don't have to worry about any of this from a Medicaid perspective. If you cannot, or if you don't want all your assets to be eaten up, or they'll be eaten up too quickly, then you definitely have to have something else in place. And what happens is, on the front end, your estate planning attorney should be building your plan in a way so that if ever you reach that point, the right tools are in place that will allow people to plan for you correctly in that moment. If it goes against that house, there are ways to make sure your house is held and dealt with so that lien won't even go against your house. I know in Michigan, it's with Medicaid recovery, the state can only take assets because you used Medicaid if a probate case is opened in your name. They can't take it generally other than that. And so we need to develop your plan in a way where that won't happen. So anyway, there are all kinds of ways that you can create a plan and adjust a plan so that you can have the best of all worlds. And this is designed by legislatures and the government. So it's not a sneaky way to cheat the government. It's things that they've put in place that allows you to take advantage of all of that and plan accordingly.
It's all about strategy. It's all about strategy.
That's right. That's right. All right. So a typical plan may include trust, a will, financial power of attorney, in mass, a healthcare proxy and living will. Then additional considerations over there. We think it is, and I always tell people, I think it's a good idea if you can afford it to get a long-term care insurance plan, because that will cover most, if not all, of the cost of that nursing home care. You don't have to worry about Medicaid. Medicaid planning, what I was just talking about earlier, making sure your plan today is built in a way where you'll be covered and empowered later on if nursing home care is ever needed. Special needs trust we talked about, and we've talked about life insurance as well. The trust is the document that at its basic level, its purpose is to help your family avoid probate court. It only works if two things happen. The first thing is the trust has to be created correctly, which is why you have to use a specialist, in my opinion. The second thing is you have to properly connect your assets to that trust. We can build the best trust for you in the world, but if you don't properly connect your assets to that trust while you're alive and able, then when you're gone, everything is probably going to still go through probate court, which defeats the purpose of doing the plan in the first place. Now, in the event that, let's say you transferred everything into your trust or connected it to your trust in the way that your attorney recommended, but you left your house out of the trust for various reasons, and then you passed, because that asset is in your name, that house is going to still go through probate court. That's the purpose of this special will that we like to call a pour-over will. It catches that asset in the probate court process and it puts it in the trust for you. Now, we don't want to rely on that will because that means probate court happened, and we're trying to avoid that. However, you still need it to back up that trust in the event that you didn't properly connect everything. Shabnam, I'm going to let you talk about 3 and 4.
Yep. Well, one more thing about the will, it's important if you have minor children as well, because unlike a trust, in a will is where you would put your guardianship wishes. So that's where you would put if you want your spouse or whoever else to be the guardian of your child. That is what the court will look for as far as consideration as who should be the guardian of your child or the conservator of your child. That's where they look the will. So that's why we always tell our clients, trust, yes, you need it, but you also will need a will. You don't just need a trust. You still need this will, this forward will. And then you have
Can you also, Shabnam or Terrence, just really quick, can you just repeat that pour-over will? I just want to allow everybody to hear that one more time because someone just asked if you can repeat that one more time.
Yep. So I will just rephrase it. A will is pretty much a document that explains your wishes and desires. So if you have your favorite necklace and you want that necklace to go to your daughter, you would want to put that in your will. That goes in your will. And then there's also a clause in your will that says anything that I left out from my trust, I want it to go into this will and then be sent back to my trust. It's a pour over. Does that make sense?
It's like an escape, right?
Think of the trust as like a big bucket. If you think of the trust as like a big bucket, the first thing is to make sure that bucket
properly attach your assets to your trust.
The way you properly attach your assets to your trust, it depends on the asset. And so that's a discussion that is better had with your attorney, because it depends on what you're doing. It depends on the kind of trust that you have. You can typically do it either via beneficiary designation, or you can change the title if it's the type of asset that allows you to change the title. Like an IRA, you can't change the title to that. So you probably will just be doing a beneficiary designation. But again, that's something that you want to talk to your attorney about, because, and we can answer more questions about this later if you have them, with assets like IRAs and 401ks, those tax deferred assets, with a general trust that you have created, you probably don't want to list the trust as a direct beneficiary of that, because it's going to be taxed. Whenever that money comes out of that asset, it's going to be taxed at the recipient's rate. And trusts pay the highest tax rate at 37 to 40%. So, you know, that's something that's another reason why you have to have a specialist creating your plan, because they will be up on that and they'll be able to rightly advise you on how to do that.
Yeah. And then as far as real estate, we would be deeding the property from your name or whoever's name to the trust. So that could be done pretty immediately after the trust is created. Bank accounts, same thing. The banks in Mass will allow you to go in and let them know that you want the bank account in the trust's name. Again, that's something that we can do once the trust is created. So it really, as Terrence said, depends on what asset we're talking about.
Right, that's right.
And then the healthcare proxy. So the healthcare proxy. So in Massachusetts, I know we put here healthcare proxy / living will, because I notice a lot of people still use the term living will in Massachusetts, but Massachusetts doesn't recognize the document living will. They recognize in healthcare proxy. So they would look at, if all you had was a living will, they'll take it into consideration. It could be used as evidence of what the party wishes were. However, what we recognize is a healthcare proxy, and that just outlines what you would want to happen in the event that you are incapacitated. So if you couldn't make the decisions for yourself, what would you like to happen, and who would you want to control what happens to you? So a healthcare proxy is very important, especially with everything going on. And it could be as simple as, I don't know what's happening. I want my spouse or my parents or my kids to decide. Or it could be very specific that says that in the event that, you know, I cannot breathe or whatever on my own, I don't want, you know, these other, you know, things to keep me alive or whatever. It could be simple, or it can be explain literally what it is that you want.
That's right. That's right. I'm seeing a few of these questions. I can't wait to get to these questions. Good questions popping up here. Let me just say this really quickly. The trust and the will are the documents that deal with that first question that we posed towards the beginning. What happens after you're gone to your assets and with your children? Number 3 and 4, the powers of the financial power of attorney. In Michigan, I call the number 4 a healthcare power of attorney, although the document is entitled Patient Advocate Designation and Healthcare Declaration. I saw some Michigan people come on, so that's for you all. Either way it goes, those are the 2 documents where you give somebody authority to help make decisions for you and handle business for you while you're alive if you need or want somebody to. The financial power of attorney is in my opinion, the better answer to the joint ownership question that we talked about earlier. If you're thinking about adding somebody on your account so they can handle business for you, to me, that's not the appropriate way to do it. Now, you got to talk to your own attorney about that. Call Shabnam and she'll talk to you about that. But to me, the better way to approach that is by doing a financial power of attorney. They don't have the right to take your stuff, and neither do their creditors. So that's just bringing it all home. I think we're ready to get to these questions. We
And
are.
one more thing I didn't mention about the power of attorney. So the purpose of the power of attorney, it doesn't necessarily mean that you're incapacitated. It could also mean that you're out of the country. It could mean that, you know, you're on vacation and you have something going on and you want this person to be able to pay your mortgage or talk to the bank or whatever. So with the power of attorney, the financial power of attorney, and massive durable power of attorney, it's literally just used so that you give someone the rights to take your place to do whatever it is that you may need them to do while you're not available.
That's right. It can be
It's
drafted in a way where they can't handle anything until after you're gone, but you're exactly right. Even here in Michigan, that can be put in place even while you're clearly able to make decisions for yourself, but just unable to for some reason.
Yep. In Massachusetts, the POA terminates upon death. So
And
at death, it terminates.
Michigan as well. Matter of fact, I got that question today. Someone asked me today, well, you know, somebody told me that my power of attorney, you know, whoever that agent is under power of attorney can handle business for me after I'm gone. Absolutely not true. That is not true.
Yep.
As she said, it terminates once she passed. All right, last slide that we need help. Let's go back to that first question that we asked you, or second earlier. Just really quickly, if you don't mind answering at tgqlaw.participo.com. What do you think now after the presentation? Now, most of you at the beginning surprisingly answered B. We're not going to sit here too long because we want to get to these questions. Let a couple more come in. All right, we're going to stop there. Let's just stop. Uh-oh, just jumped up as soon as I said that. All right, let's just go.
20.
Overwhelmingly, people are saying B. They think their plan should probably include a trust. And again, you know, your attorney will help you decide that. You know, we'll be straightforward with you. Trusts cost a lot more than wills do. I know here in Michigan, if you do a will plan, which includes powers of attorney, the trust plan that includes a will and a power of attorney is more than twice the cost of a will plan. But now that you've heard some of the benefits of a trust, you probably see why. By the way, one other quick benefit of a trust, in my case, I have two children who are minors. They're 14 and 11. My wife and I, we have that trust plan in place, and our plan, all of our assets pay into our trust whenever we pass. The trust then uses money for the benefit of our kids while they're growing up, including paying for college. But then it says whenever either child turns 25, give that one a third of whatever is in his or her half of the whole pot. At 30, give them half of what's left. And at 35, give them the rest of it, and the trust ends. You can't really do that with a will without creating a trust in the will, which doesn't, to me, always make sense. The trust is what's designed to allow you to take care of those children. And by the way, in that minor children situation, where you maybe want someone else to manage the money other than the other parent of the child, the trust allows them to do that without court being involved. So just something to think about. Your move. Don't think too. Checkmate.
All right.
Here's the information. Contact information for anybody that wants to get in touch. The next slide, we're going to jump right into the questions, but we will sit this here just for a second so that you all can write down the information.
You can screenshot it.
Quickly. And then I'd imagine, I don't want to speak for Michelle and Denisha, but I'd imagine that the information may be posted somewhere in case people have follow-up questions.
Yes. After this, probably by the end of this week, we're going to share the video with everyone, including a copy of the slides if you wanted to put notes on it, and all of your contact information as well. We encourage you guys, definitely, if you have questions, to reach out to these attorneys. They are an invaluable resource to you, and we want to you guys.
Question time. All right. So That survey at the bottom is for later. That's not how you send a question. You put your questions as you all have been doing. Go to the tgqlaw.participo.com, and that's where you can list your questions. But at some point, please do also fill out this survey. All right, let's get into these questions here. Let's see here. What do we have? Uh-oh, messed up. There we go. How about separate joint assets? Have a main account for me and husband jointly. Then open up joint accounts for my 2 older kids. Assets accounts, but they can't access mine. You want to take this? You want me to take it?
You can take it. I'm going through these questions.
Yeah. So, like I said earlier, I think that the jointly owned with your spouse is fine. If you're fine with it, I am. But with nobody else. Now, in this case of these accounts for your kids, if that's really their money, it's fine. I think it's fine until they are adults. I just, and again, remember this disclaimer at the beginning, none of this is legal advice. You got to decide for yourself what you want to do. I just don't like the idea of joint accounts. I have accounts with my minor kids now as they're building their money. They're their accounts, but I'm the adult. When they turn 18, I'm taking my name off of those accounts because I don't want them to be subject to any issues I might have. Hopefully I won't have any, but I don't want them subject to any of my issues.
Yeah, and remember what I said earlier, if something were to happen to you, then half of the money will go to your estate, not over to your child, unless you put in that clause that says, it's survivorship.
Yeah. Yeah, great question. Next question. I think that the country, if they're a U.S. citizen, then I believe if they live in the United States, I think the United States will be what counts. So wherever they're domiciled in the United States, that state.
What's the name of the question, Terrence? What was the question?
Well, it says, what if the person who dies is a U.S. citizen and dies outside of the country where they were born? Which country will come into play? So I'm assuming this is asking, I think this is asking, if you're a U.S. citizen, but you're out of the country when you die, what country laws govern? I think for purposes of your assets, the laws in the United States would govern, except if you have assets out of the country, that country's laws will govern those assets that are out of the country. If you have a vacation home in, Belize, I think that law will govern that home, but your United States or state-specific laws will determine how everything else will happen. I know if you're a citizen of Michigan, if you're domiciled here in Michigan, a probate case, if you don't have the right kind of plan, will have to be opened in Michigan. And then if you have property in other states or even other countries, you likely will have to open a probate case there in order to get access, or your family will, to get access to those assets.
Same in Mass. That's exactly the same. So if you died in wherever in New Mexico, in Mexico, and you live in Massachusetts and have property in Massachusetts, you still have to open a probate case in Massachusetts.
Mm-hmm. Yep.
Deal with that.
Good question.
Okay, great. Now, are you guys answering the questions that are coming through that?
I'm using the app. Yeah.
Got it. Okay, because I also have about 18 questions on my side from the chat box as well.
Okay. So let me go through these first, and then if we have time, we'll go through yours.
Yeah. How do you get the designation of rights of survivorship? Chapman, let you take that one.
It depends. Usually you just talk to your bank or whoever. You just say, hey, I need a form. I want to designate the rights to whoever I want, and they'll give it to you. So that's just a conversation with either the bank or whoever.
And then if it's a deed, then you definitely have to spell it out as well in a deed to property.
If it's a deed, yes. So then my office or whoever, an attorney's office, they will create that they'll prepare that, and then you'll sign it, and then we'll file it at the registry of deeds if it's a deed. Yeah.
Did you say if my assets are in a trust, the person has to pay 37%? This is a great question. I'm glad you asked this to clarify this. That's not necessarily what I said. I was talking specifically about tax deferred assets. So if you have a traditional IRA, a 401k, a 403b, a 457, those types of assets where you've been saving pre-tax money and you have not yet been paying taxes on the growth of the money, Uncle Sam is waiting to get money, and that's why he forces you to start taking money out if you haven't already. As of this year, at age 72, you have to start taking money out of those, and the reason is because they want to start collecting taxes on that money. So whoever is the recipient of that money, whoever's getting the money, whether it's you while you're alive or a beneficiary after you pass, when they get that money out of that asset, and again, I'm just talking about tax deferred assets, the money is going to be taxed at the recipient's tax rate. So if the recipient is a trust, because you listed the trust as a beneficiary, trust tax rates are 37%. Now, I know you're also asking about what about all the other assets, because we get this question a lot, life insurance and all of that. There should be no tax on that money when it hits the trust or when it comes out of the trust. I was just talking specifically about tax deferred assets. Great question.
Right. Life insurance proceeds, that's correct. Life insurance proceeds are not taxed.
What happens in the case where a husband and wife are separated, not legally, just no longer living together? The spouse dies, who inherits the assets, the children or the spouse? You want it or you want me to take it?
I'll take it.
Okay.
So a separation in Massachusetts is not a divorce. So if you have a plan in place, it would go as your plan designates. But if you don't, then it will go as if you were living together. So just because you're separated or living apart, remember Massachusetts doesn't really recognize separation. So they would still get their share. I think it's a half of your assets plus the first 100,000, something like that. Don't quote me.
Yeah. Now in Michigan, it's exactly the same, except, and lawyers always have an except to everything, except if it's proven in court that you have completely cut that other person off, then a case can be made and won to show
Same.
or to stop that from happening. Yeah. So now that's where the law in the books differs from what the courts have said. And so basically what that means is if it's shown that, and I forgot the exact terminology, but if it's shown that, you just don't even care about this person, you all don't communicate, I forgot the word that they use, it'll come to me later. You have to prove that. And if you do, then, it won't transfer. The rule of thumb is, though, if you're separated and you don't want that person to get everything, then you need to make sure you make that clear in your documents.
And it has to be very clear, because I have a case right now where the parties were separated for over 20 years, not living together. Literally, he has a different wife in a different country. Obviously, we don't recognize second wives.
I was just gonna say they have to be from the Caribbean, because listen, all my Caribbean people that are out there, listen, that's big in our community.
Yes.
Just saying, 100.
that first wife is going to still get her share, not the second wife and the adopted children of the second wife that you decided to raise. It's a real thing.
Yeah.
So
yeah.
Listen, it gets sticky, you all. It gets sticky.
Yeah, that's a big thing in Caribbean culture, and I've seen it. I mean, I'm
in
talking
the
about
African
separate
culture too.
Yes,
So
separate
Nigeria, Ghana.
houses. Yeah, yep, that's
Yes.
big. That's big. And law doesn't recognize that those emotions, you guys. You guys got to tighten up that paperwork, okay?
Right. That's right. Law doesn't care about that emotion. This is a very good question. The 23-year-old that sent this question in, thank you so much for asking this. For the other younger people, I remember when I was 23, the other younger people who are on here. Great question. So my response to this would be, if you're 18 or older, you are not too young to figure out who to leave your assets to. I have a rule of thumb. If once you turn 18, regardless of what you, I don't even need to know what you own. If you're 18 or older, there are 3 documents at least that you have to have, in my opinion. That's the financial power of attorney, who will handle money and bills and all that for you. If you're alive, you need somebody to. Healthcare power of attorney, which we've talked about earlier, healthcare proxy in Massachusetts, making medical decisions for you. That's significantly important.
Yep.
And also either a will or a trust or a combination of the two to say where you want things to go. In your case, maybe you want everything to go to your elderly parents. And right now, probably, I'm imagining the same is true in Mass, in Michigan for sure, those assets are going to go to your parents anyway. What else you could do, depending on the type of plan that you have, is you could discuss in your plan how you want it to go to them and where you want it to go after that. And maybe there's a distant relative or a charity or something like that that you'd want it to go to. Or maybe there's a close family member that you definitely wouldn't want it to go to. And if you didn't plan correctly or didn't plan at all, that asset might end up in that person's hands. So no, you're not too young. Do a plan. And as you build, keep on adjusting your plan.
Yeah, great questions, you guys. Awesome questions.
Everyone should have now. Go ahead. You can take this one. I was talking too much on the last one.
And Denisha had told me that she took the questions that are in the chat box, Shabnam, and sent them over to your platform as well. Okay, so I'm good on mine. I just wanted to make sure that we keep our word and answer the questions that come in from both of these sources. Okay.
Perfect. It's perfect. Okay, so what are the basic documents everyone should have now? Example, by the end of the month. Okay, so exactly what Terrence just said. So it really does depend on where you are in your journey of life. But if you're in the younger, so 18 in Mass, you can start you can get a trust or will, whatever. So 18 plus. So we would recommend a power of attorney, a will, healthcare proxy. As you start to grow, you have a career, you get married, you have a house, then you want to enter the trust. And then you go from there, depending on your needs. When you have children, if you have a special needs child, then you want to talk about a special needs trust. If you have pets that you love so dearly, then you would start a pet trust. So it really depends where you are. Okay, let's see.
Questions, good questions.
This is for you.
Their wealth from where the majority of your clients maintain their wealth all over the place. Some of them inherited, like we saw that one of the first slides that we had. In addition to that, property, a lot of my clients build through rental property, investment property. They're saving while they're working. So they have 401k and IRAs and those things. Life insurance is very big. Life insurance, a lot of people say to me, just out there, I'm not getting a big life insurance policy. I don't want to, I didn't get that when my parents or whoever passed.
Very true.
They got to work for it, or why do they need more to bury me? That's a big one. They'll say, I just got enough to bury me. They got to figure the rest out on their own. And everybody's can make their own decisions. I don't think that's a proper approach. I don't think that's a good approach. I'm all about generational wealth to the next generation and generations to come. And so I am a big I don't sell insurance. So I'm not saying that for that reason. I'm a big proponent of life insurance because it's a simple way to leave significant wealth on the next generation and can change generations. Let me just do this. I'm sorry. Can you all imagine, and maybe some of you had this happen, if you were 35 or 25, just getting out of college or just trying to make it, and someone passed, which we don't hope that happens and we don't want that to happen, but it did. And all of a sudden, a life insurance policy, a company called you and they paid out to you, $200,000. Think about you at age 25 and how that could have changed the game for you. Or maybe it was $2 million, how that could have changed the game for you. And that happens in other cultures, as that other slide showed earlier on. I think it's a big deal. Go ahead, Chapman. You can take this one.
What if your parents doesn't have any assets or a will? What is the best plan of action to make sure they're taken care of in the future? This is a good one. This is a good question. If your parents don't have any assets, it literally falls on the children. What I recommend is getting a life insurance plan for your parents, so that when, God forbid, something happens, at least you have the assistance to pay for the post death items. While they're living, it's going to fall on you. So you have to make sure that you have your whatever your thing is in place to be able to take care of your parents, because we have to take care of our parents.
Yeah. In addition to that, I would add, everybody again needs powers of attorney, and certainly as we age, we need to have. We need them if we're 18, but certainly as you age, you want your parents to have powers of attorney, because that's what's empowering you to handle business for them. If you don't have it and they can't handle business for themselves anymore, you're going to run into a lot of walls, and you're going to end up going to court, paying a lot more money. It's going to be much more public in order to get authority to handle business for them. Other thing is, I think it's always worth it to at least get a quote on long-term care insurance. That's another tool that I think is huge. Now, it is very expensive, and the older you get and the worse your health is, the more expensive it is. I still recommend to my client, get a quote. It doesn't hurt, doesn't even cost you anything to get a quote. And I tell people, if you can afford it, I recommend that you get it. That's what I tell my clients. If you can't afford it, you just can't. And the reason is because that long-term care insurance policy can satisfy the costs that will occur if they need nursing care. You don't want that coming out of your because it's significant.
Right. I'm just going to add on to two things that you guys had mentioned. Again, we had you guys that were here last month. The event was all about life insurance, and the idea is not just about your life. It's about just like these guys are talking about. Okay, we can't replace you. The idea is replace your income, because when that income stops coming in, somebody's quality of life is going to be affected. Either yours, because now you're going to have to take on the burden, or whoever else that's left behind. You're completely irreplaceable, but the life insurance is there to replace your income, as well possibly as satisfying any debts that you may have. Just like they talked about earlier, when you go away, your debts don't go away when that person goes away. Terrence talked about the long-term care. Again, if you have pre-existing medical conditions, just like with life insurance, you don't buy these things, you got to qualify for it. This is why we stressed at the last seminar is, again, just like he said, it doesn't cost you anything to at least get a quote to see where you're at. The younger that you start, the better, especially if you're in good health. These costs are lower. People go, well, it's too expensive. It's going to cost too much. It's going to cost you more if you don't put these things in place. Especially speaking as an only child, these guys talked about having that power of attorney. I'm an only child. My mother was an immigrant. I had to then become a caregiver because my mother had a stroke at 45. No one thinks about becoming a caregiver in their 20s, and nobody thinks about that happening when they're in their 40s. That I'm going to take care of her. But because I had the ability to have an attorney help me with that power of attorney, I was able to still handle my mother's financial matters and not have those things be a burden to me. So I'm just talking to you from personal experience. Please, if these guys are taking their time out of their schedule to give you the answers, make sure you take action on these answers that they're given. You can continue. Thank you.
Can you create a trust for your primary home if you have an active mortgage? Yes, you can. But you want to just make sure that you communicate in some form or fashion with the mortgage company. It shouldn't end up making a difference, but you and your attorney should talk that through. The answer is yes.
Yes.
Next question here.
Sorry, it's loading.
Okay.
I think a lot is coming in now. I can just ask it. How about if you did a prenup, would the spouse get it all?
If you did a prenup, it depends on the terms of the prenup. So if you did a prenuptial agreement, which is an agreement, of course, most know, an agreement where you agree which assets will remain yours in spite of marriage, that prenup should speak to that. So I would have to see the agreement in order to really answer that question. Typically, whatever assets you have that were not mentioned in that prenup will end up going to your spouse. Whatever assets were agreed upon in that prenup that would stay with the person who passed family will happen like that. So it depends on the terms of the agreement.
And we always ask at our meetings if there are any prenups or postnups that you send it over, just so that we can make the documents the same.
That's right. That's right. So I see a question on here that says, who do I contact to place my trust, someone as my healthcare proxy? Shabnam, you contact your attorney. And we're gonna do contact your attorney. I never recommend using an online form. Matter of fact, I just did a YouTube video on my YouTube page just last week where I said, no, don't use online documents. Don't use will kits and purchase document. Call an estate planning specialist. So call Shabnam if you're in Mass, call me, period. If you're somewhere else, call one of us and we may be able to help you find an attorney to help you. Matter of fact, I know there's one here now from around the country who do this. A couple of them are on here now. If I have an existing will or estate planner and I want to make a few changes, this is the one that I saw earlier that I said, I can't wait to get to the questions. Do I have to go to an attorney or can I type corrections and just have it notarized? Please do not type corrections and have it notarized. Please. I wish I could scream it, but you all get mad and say I was being rude on here. Please, please, please. And I'm saying this and I may never meet you again. This is not me trying to get your business. Please do not write on it. Don't type on it. Just read it and call your attorney and have them change it. It took us, I know it took me 3 years of law school, a 3-year course after law school to get certified, to get a certificate in doing this work, and then years of another attorney walking with me to know how to do this stuff correctly. Please don't write on it. You need a specialist to help you make sure those changes are correct.
And in Massachusetts, you can't just, those changes, they don't come in. You need a codicil, and that's pretty much typed up or handwritten, doesn't matter, but it has to have the same requirements as a will. So it has to be signed and it needs to have 2 disinterested witnesses on there. So it's not as simple as like you just cross something out and write in it.
This next question, I want to do a will and/or trust. I don't have a lot of money. Is there a certain amount of money I need to have in order to get started? That depends on your attorney. I'll let Shabnam speak for herself, and she's talking about in Massachusetts. As a matter of fact, I'll let you answer it since they asked specifically about.
So it depends. It depends on your situation. It depends on, what's happening. I work with my clients with what they have. So if it really depends on the attorney. I've never turned away a client who wanted to get their financial situation or whatever in place. I've never turned on a client. So we usually work things out. Yep. So I always encourage them to do something now, and then we can do something greater later if they need to. But I always encourage them to have something in place: the will, the healthcare proxy, and the power of attorney.
That's right. The deal is get in touch with an attorney, and they'll walk you through this. So get in touch with Shabnam, and she'll walk you through this for sure. How to avoid inheriting debt from spouse, parents, etc. I always tell people, there's an article on my website about this. I always tell people that you never have to personally satisfy debt that you never agreed to pay. So if you've never signed up to pay it, you never signed you never guaranteed something for somebody, which I don't recommend, don't co-sign, then you never have to pay it. Now, if it's your spouse, even if it's your spouse's debt and not yours, you shouldn't have to pay it. Now, that's qualified. It depends on what kind of debt it is. But depending on your situation, you may not have to pay your spouse's debt. So that I think my real answer to this question is never sign anything saying that you will pay it. Don't co-sign. If you didn't co-sign, if you didn't sign at the bottom line, if you had nothing to do with it from the beginning, you should not have to pay that debt, whether it's a spouse, parent, or anybody else. Chap, you want to add anything to that?
Yeah. But just remember that if there is an estate, those debts will be paid from the estate. So your debt dies with you. However, if you have money in the estate, usually they'll file a lien with the court. If let's say if it's not in trust, let's say you have a will in the estate, they will file a lien, and those liens have to be paid if you have money in your estate.
Yeah, that's right. So remember earlier when we were talking about time, cost, and publicity of probate court, a major reason for the publicity side is you have to publish in the paper a notice to creditors. Here in Michigan, that's what we call it. It's probably similar in Mass, letting them know that the person passed so that then any creditors can show up and say, we want to get paid. And so, yeah, but you aren't inheriting that debt. The estate is paying that debt. So, she's exactly right. If probate happens, or even with a trust, you're going to have to satisfy debt first out of the estate, not out of your own pocket. Who do I contact to play? Oh, we did this. This is one we read earlier. Contact Shabnam to do your healthcare proxy.
And then what we do is we those paperwork, we give it to your doctors, we give it to whoever would need it.
Mm-hmm. Yeah, that's right.
This one. So the next question is, can a person have more than one will or trust at a time?
Yeah, yes on a trust. Really, the answer is no on a will. Aretha, they have 3 different documents that are supposed to be wills. And that's part of the problem. They're trying to decide which one should be used. Trust, you can have multiple trusts for sure. And some people do. Some people do.
Yeah, and there's so many different types of trusts. So you can have a family trust, you can have realty trust, you can have pet trust. So you can have a trust per property. So that, yes, but we always for the will, we say that any other prior wills, they're not legit. They're terminated.
That's right.
Just so that we can have one final will. It doesn't make sense to have multiple wills.
That's right. The most recent one is the one that governs. And typically, almost every will revokes.
Yes.
That revokes all prior wills.
Yep. All right. I'm going to just ask this question because I think it's too long to post on here. But because our children have disabilities, should my husband and I put the house in a special needs trust or their names directly? When should that happen?
Yeah, great. That's a fantastic question. Thank you for asking it. Very important question. The answer is probably. Now, remember, we're not giving you advice. What I would encourage you to do tomorrow is contact an attorney. If you're in Michigan, call me. If you're in Mass, call Shabnam and start that process right now. When should it start? Immediately. And the reason is because it's too risky of a situation. You could end up causing disqualification. Your plan probably will likely involve a special needs trust that will capture your assets either now or later upon your passing, so that then they're positioned to take care of your child or children, but not disqualify them for potential governmental support. The family, so everybody needs to plan yesterday, no matter what your situation is. I mean, everybody on here, and again, please know this is not me just trying to get business. Everybody on here, I encourage you strongly to contact an attorney tomorrow who specializes in this area. You have 2 of them on here right now, and start the process in some form or fashion. If you're in a special needs group, if you are a parent of a minor child, if you are a blended family, I think it's even higher priority, even though I don't know how you get higher than the highest. You got to do it. All right. How do I pass down my 401k account funds if I pass before I can use it? Very good question. You want to take that, Shabnam? You want me to get it?
Well, the simple answer is that usually you have a beneficial form that you complete at that time.
Yeah.
You tell your employer.
Yeah. Now you can, I know I'm about to contradict myself, everybody. I said earlier, it's not the best idea to list your regular trust as a beneficiary because it's going to be taxed. But you can have what I call, and I just made up this name, a retirement benefit trust created that's designed to capture those funds when you pass, but not be taxed like it would otherwise, and then distribute those assets over time to whoever the beneficiary is. Now, as of this year, and I'm not getting real deep into this right now, but as of this year, there's a new law that only allows for most beneficiaries that you would list. It only allows that money to be spread over 10 years. It won't be able to be spread over a lifetime like we used to be able to do. But anyway, either through beneficiary designations directly to the person, to answer this question, or you can send it to a special trust that's designed to not be taxed. You can send it to the regular trust too, but it's going to be taxed. What taxes are?
One more comment about 401ks or 401s is do not put a minor unless you put a custodian with it. Because if you put a minor down, then what happens in Massachusetts is that you still have to go to court and get a guardian appointed. Yeah. So you want to put a custodian for your children, you can do that.
Yeah, and in Michigan, you have to get a conservator appointed. And that's a little difference between Michigan and Mass. The conservator in Michigan is who will handle that money for that child. Just the terminology difference. What taxes are associated with transferring wealth? How do you limit this liability? We kind of just talked about that. So with all assets other than retirement assets, tax deferred or even taxed retirement benefits potentially, there should be no tax. However it's transferring, and then with others you can do the retirement trust. This may be off, but will property being given to you or put in your name, will that affect you when attempting to get a property as a first-time buyer? Shabna, this is you.
No. So in order to qualify a first-time home buyer, you are getting a mortgage for the first time. So if you get a property inherited to you, then you're not taking out a mortgage. So technically, you're still a first-time home buyer.
This is good info. You're sharing some good stuff, my friend.
I have this next question for you.
What do you all think about digital assets? I think almost everybody has them now, like social media, websites, etc. How should we plan for that as part of our state? In Michigan, about 3 years ago, we passed a new law that allows you to identify, designate who you want to handle that stuff if you become incapacitated or whenever you're gone. So first of all, I think you should make sure you appoint somebody to be in charge of that. Now, I think all now the social media sites also, you got to find it, dig through the settings and stuff to find it, but they have a place where you can identify who you want to be the person to control your Facebook page if you die. I mean, think about that. When somebody passes, who can pull their pictures down and things. So those are a couple of ways. Other than that, it's just like any other asset. Send them to whomever you think should get them. And you can do that through your trust if it's an asset of value, or through your will. Does it make sense to form a trust in other counties? I know a lot of wealthy people do. I think it must make sense to them.
I'm like,
yeah.
No, I want to say no. Not if you don't have any assets in other countries.
So is this countries or county? So let's answer both. So the only one benefit that I can think of setting up a trust in another county is if you know the trust is going to be disputed and it's a county where you know the court system operates well or in a way that you like, or if you know you live in a county where you know there's not going to be a good result in this, contested court issue, then it may make sense to establish the trust in another county. Some people do that, and that's probably why in some cases. But ultimately, just generally speaking, for most people, no. It for regular everyday people, it probably won't make a difference.
I'm going to ask you this next question. If your beneficiary passes shortly after you do, who gets your money?
That
How many
beneficiary,
beneficiaries can you have on one policy?
yeah, if you have, if I, well, I don't want to do it that way. Yeah, if I list my brother and I don't have one. So if I list my brother as a beneficiary and I pass, and then he passes a week, 2 weeks later, let's say 3 weeks later, that money's going to pay out to him. And he's gone, which means his family, and actually that's happening in the case that I have right now.
Mm-hmm.
His family is going to have to open a probate case in order to get that asset. So it gets kind of tricky. Question. What's the next one?
This is the last one I have here.
Okay. I've heard that life insurance can be used as a tool. Yeah, we talked about that earlier. Absolutely. I think it should be used for that purpose. And there's an in-house debate among insurance providers, and I know this could get controversial. There's an in-house debate between insurance providers of what types of policies you should have. Is term good? Is whole life good? When should you buy one or the other? I don't have a dog in that fight, or how do they say it, a pony in that race, or really, y'all know what I'm trying to say. I don't benefit from talking about it on either side, and I see the benefits of both. I think it depends on your situation. I don't think, in my opinion, I don't think either side is right. I think both of them are right, if that makes sense. The main point is, yes, you should get life insurance, in my opinion, for sure, and use that as a generational wealth tool. It's a cheap way to send what could be significant wealth to the next generation. And one other thing I'll say about that, and I'll stop talking so much. When somebody passes, it's hard. And if there's a benefit like that passing on, you never know what that might do to them in addition to providing for their future. A lot of times I'll see a husband who's the breadwinner in a traditional household have life insurance that covers him, but not have any that covers his wife who stays home and cares for the children. And I think that's a bad idea. I think, in one of the reasons why, among many, if the life passed, a lot of times that husband has no clue how that's going to impact him. Hopefully it impacts him, but he doesn't have a clue how that's going to impact him. And a lot of times they want to stay home and they just can't go to work for some time. And if that life insurance was there to pay out because this wife passed in that scenario, that can provide an opportunity for them. So yes, I think that's great.
And another benefit with life insurance, if you have that cash out option, you can actually take out money from your life insurance policy at a certain age to use in whatever manner you want.
Yeah, yeah, and that's talking typically about a whole life policy, and that's one of the benefits of it. Some people believe that you should only have term. I think you have to look at what's best for your situation, and I think you have to decide on that. And yeah, you're right. That a lot of people, I know a lot of people who've used that cash out benefit to their advantage. Got life insurance today and died next month. Will her family still be set? Depends on how much life insurance she had. If Sally got $10,000 because she was of the mindset of, I just want to make sure they're buried, they might be set for not having to bury her. But after she's buried, there's nothing there. And I know I keep saying it over and over and over. And I think I need to get some of these life insurance companies to pay me to say it without me having to sell it. Because I'm a huge proponent of life insurance. I just think it makes sense.
All right, this is the last question. What if you never marry and have one child? Do you still need a will or a trust?
So you can't really answer. Can't. So absolutely, you need one or the other. If you're 18 and older, no matter what your situation is, I think you should at least have a will. Period. I hear somebody asking why. I know you think you don't have any assets. One, you'd be surprised what assets you do have. Number two, what if somebody left you something? You didn't know they were going to leave you something. You can at least direct where that will go. Now, do you need a will or a trust? That decision is for me based on a number of things. At the outset, I always ask I have a lot of people call me and say, I just need a simple will. I don't need a trust. I don't need all that. I said, okay, no problem. I said, would you be interested in your family going through probate court? Well, no, that's why I want a will. Well, we talked about it already. With a will, you're going to go through probate court. So that's the first question. But then as we look at assets, as we look at how you want things distributed, you want them distributed over time in some way, you're talking more trust. But then that plus the amount of assets that you have will help us decide if we really want to recommend a truster. The answer is yes, you need a will or a trust for sure. Whether it's a trust depends on the conversation you would have with you individually.
Exactly. I think that's all the questions we have.
Is that the finish line?
Let me see. Yeah, that's all the questions I have in the app. Michelle, I don't know if you have questions.
Denisha, anything?
And Denisha, was there anything else I'm missing?
No, everything that was in the chat, we've also added to the platform. So you
Perfect. So I got all of them.
Yeah.
Wonderful.
And again, we're here, not on the Zoom call, but we are here. You have all our contact information. If you have additional questions, I'm happy to respond. Email is best if it's just a question, or if you want to talk about it, you can call me. Terrence is also available. And between the two of us, we probably know an attorney in every state. So my question wasn't added. Okay, Jesse, what's your question? Let's see. I don't see a question from.
I see one question here that says, if a person relocates to another state, should that person wait until they're settled in that state before doing a trust? And our trust law is different from state to state. The answer is yes, they are different. They aren't always drastically different. I always encourage people to just do your plan. If you know you're leaving next week, for example, I have a client that's moving to Florida, and Chad will be in touch about that. Client that's moving to Florida right now and not update some of their documents last week, because I think they should do them in Florida. However, I don't think you should wait. If it's like a week, maybe you can wait. If it's longer than that, I think you should just get it done.
Yeah, anything can happen, as we see with COVID and everything else. So you just never know. You always want to be prepared.
Yeah. I see one more. What's the basic cost of completing a trust with an attorney? It varies. It can be anywhere from, and by the way, when you say trust, or when I say trust, I'm not talking about one document. I'm talking about all the supportive documents as well. So the will, the powers of attorney, and for me, it's about 6 or 7 other documents that tie it all together to make it effective. Depending on your situation, it can cost anywhere from, I'd say, $1,800 up into thousands. Most people, for me, paying somewhere between $2,000 and $4,000. And I know that sounds like a ton to some people. In the grand scheme of things, when you see all that it does, and when you go through that meeting, you see that it's a drop in the bucket compared to its value. It should cost more. And some people charge a lot more. I just don't, because, I charge what I think you should pay.
There was this question. Do you lose your residential exemption benefit if you transfer your name on a deed to a trust in Boston? So there's 2 parts of this question. When you talk about residential exemption, are you talking about the one that you received from the city of Boston? If so, as long as you're a trustee or beneficiary of the trust, you won't lose your exemption. And if you talk about the homestead exemption, then you don't, because what we do is we file a homestead for the trust. So we just file that with the trust, and then you don't lose that. So it depends, but most likely no.
Cool. I think, is that everything? I think we're done. I know we're past our time.
Yeah, thank you both so much for taking time to really engage everyone and answer all of their questions. We want you guys to take action. The goal of this session, one, is to provide information, but it's really to make sure that you see how important and how valuable this is, where you can't delay. We don't know when we're going to die, right? It's a tough conversation to have, but we don't know if we're going to wake up tomorrow. So that's why these things are important to set in place to make sure that your family will be supported and in a better position if anything were to happen to you. And it's a conversation that you have to have with your parents, with your aunts and your uncles. I'm having those conversations. As much as I've talked about life insurance and getting a will, my father still doesn't have one or a trust. And it's a conversation you have to keep having, because it's where I think for the older generation, they assume it's as simple as, when I die, this is what will happen. It's just going to go to you guys. And it's not that simple, because we've just learned tonight that it will go to probate. If you don't have money to pay for probate, then that's funds that you have to kind of find, or it's coming out of the estate. So you want to make sure you set these things in place. We will have the contact information of our attorneys for you guys to follow up with. We encourage you to please do not procrastinate and follow up with them. Send them an email and schedule your appointments to have those conversations. Thank you again. Michelle, do you have anything to add?
I think she can't get off mute.
She's saying she's...
What happened? I just... Hold on.
Okay, how about now?
Yeah, I'm here now. Craziness. But anyways, I thank you guys so much for participating in our Building Black Wealth seminar series. And I'm pretty sure we're going to have you guys come back again. Thank you, everybody, for just presenting some fantastic questions to Shabnam and Terrence. I mean, let's give them a big hand. I mean, they took the time out of their schedule to be here and to pay it forward this evening, and we like that. They're on the same wavelength about being able to give the same type of quality service and care to our non-melanated parents, and we really need it because we get paid the least, and we get and we work the hardest. And again, based on their survey, as you can see, that we don't we don't have these things in place. And it's just awesome to know that we do have representation in our community of people that look like us, that are helping us. So please reach out to them. If you currently have your own attorney, definitely do that. And these guys that gave a disclaimer that they're just here, sharing, but definitely reach out to your attorney that you are cutting checks to, okay, to do that. If you don't have one and you want Terrence to be able to help you. Again, he's in the state of Michigan. Shabnam, she also practices law here in Massachusetts, Florida, and I believe New York. Shabnam.
Yep.
Yeah. So yeah, in three states. Also, too, I know some of you guys may have a prepaid legal through like an outside. I know some of you guys that are on here have that. That's the same type of service that you can get. Updated wills and trusts and those things like that. But again, the whole idea is for us to take action. And Denisha and I just want again to thank everybody for always just encouraging us, but then helping us level up to bring quality people like Terrence and Shabnam here to bring the information to you. Again, makes no sense for us to build the wealth and then not put the foundation things in place for us to be able to enjoy it, but then most importantly, to be able to pass it down properly. So again, on behalf of all of us here at Building Black Wealth, we thank you again. Thank you again, Shabnam, for Terrence, for coming this evening and sharing. We will be sharing their contact information. This video is recorded. It will be posted. So definitely look for that video. of this recording on our Village Initiatives Facebook page. It will be posted on there. Be sure to like and follow the page, so that way when the next events that are coming up, because we do have a great lineup for you, we are still working that out. Definitely go to the Eventbrite to kind of just to register, so you guys can kind of know what's going on. Okay. Feel free to send Denisha an email. Denisha, I don't know if you want to pop in your email at in the chat box, but I believe it's in, because I just do it haphazardly in my email, right? So I believe it's info at ourvillageinitiative.com, right? So info at ourvillageinitiative.com. And again, we will be putting Shabnam's information and Terrence's information. Listen, even if you don't live in Michigan, and you have family that do, this is the guy to go see, okay? I mean, just a variety of knowledge. Shabnam, I mean, New York is like a hop, skip, and a jump away. Here she is. She's a sister. She's like one of us. Definitely feel free to reach out to her, because again, she doesn't just do the law part. She also has that real estate component. So not only, again, here at Building Black Wealth, can we get you in position to buy a home, but Denisha can get you the home, and then Shabna can show you how to protect and guide that home. This is what we do here at Building Black Wealth. So again, we want to just to thank you guys for always for your support. We always want to continue to level up and bring you quality content. So thank you on behalf of Denisha and myself.
Thank you again, Shabnam and Terrence. You guys are amazing. I am forever grateful. Amazing content tonight, and I really appreciate that you took the time to answer all those questions, because you didn't have to go over the time, and you guys did. Extremely appreciative. Terrence, please share this event, because this is just as important.
Yeah, so we the month of July for me, I'm doing a lot of content on my site and on my YouTube page for business owners. And so we're doing a panel discussion. We do some kind of panel discussion every month. And this month is all about why every business needs an accountant. I have had sidebar conversations with each of these people, which I've worked closely with over the years. In the last week or two, the information that they are going to be sharing, I'm telling you, the information they're going to be sharing is amazing. We have a meeting on Monday night to finish preparing for next Saturday. I can't wait to have that meeting, get more info. If you're a business owner, you're thinking about starting a business, if you just started a business, if you've been in business for a while, like Shab and I, or if you're big business and you're rolling, you want to be on this webinar, or anybody you know does, because I'm just going to ask questions and let them talk, and they're amazing. I'm excited about this, as you can tell. So next Saturday, July 18th at 10 a.m., it will be on Zoom. That's where you register on the website, tgqlaw.com/events, and you'll find it there. And I'm gonna just let them run with it. It'll be great.
Awesome.
Perfect. One last, on August 12th, we will have our tax strategist coming in to speak with you guys. So whether you're a W-2 employee or 1099, learn how to file your taxes correctly so that you are not giving money away. There is a strategy to filing your taxes. You are probably paying too much because you didn't ask the right questions. So we want to make sure that we get those questions answered and really help you build wealth.
Yeah, I was going to say that's definitely another way to build wealth.
That's right.
Taxes. Yeah.
Yep. Taxation strategies. Absolutely. Again, once again, it makes no sense to build the wealth, to give it away to the state, or give a lot away to the IRS. Again, not tax evasion, taxation strategies, you guys. Right. There's a difference. But awesome. Thank you.
Thanks, everyone.
Thank you all. This was great.
All right.
This is great.
So thanks everyone. So again, please stay in touch with